Good morning, a very warm welcome to everyone who has joined this webinar. It's hosted by Landmark Chambers, and it's a quick recap of the significant planning cases that took place in 2021. My name is Matthew Fraser, and I'm joined by Matthew Dale-Harris, and we're both barristers at Landmark Chambers, specializing in planning and environmental law. As you can imagine, inevitably, we've had to be quite selective, and we won't have time to go into the finer details of any of the cases we're talking about. But what we've tried to do is highlight the main judgments to note from the past year. And it has been a busy year for planning case law. We're going to alternate as we go through, and everyone should feel free to ask any questions via the Q&A box, which will be either at the top or the bottom of your screen. If you would like to remain anonymous when asking a question, then please make sure to tick the send anonymously box before submitting your question. We'll try to answer them if we've got time and if we know the answer. Do feel free to get in touch with us by email if we don't manage to cover anything that you've asked. A few other housekeeping points. Your microphones are automatically muted, so you won't need to adjust your local settings. And also this webinar is being recorded. You will receive a link to the presentation and the recording shortly after the webinar concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. Okay, just flip over to the first couple of slides. So that's us. We're going to start with a few cases concerning the interpretation of various paragraphs in the National Planning Policy Framework, which is always a hot topic for litigation in planning. The first two can really be taken together. They were handed down right at the beginning of last year, Paul Newman Homes and Monk Hill, and they both concern perhaps the most important and controversial paragraph of the planning framework, paragraph 11D, which provides that where there are no relevant policies in the development plan or the policies which are the most important to determining the application are out of date, then planning permission should be granted for an application unless one of two caveats applies. The first is that the application of a particular policy in the NPPF provides a clear reason for refusing permission. And secondly, that the adverse impacts significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole. And that's known as the tilted balance. Both of these judgments arise following other big judgments on paragraph 11D from 2020, thinking in particular of Wavendon in the High Court, Peel in the Court of Appeal, and also Gladman in the Court of Appeal right at the end of 2020. So this is a paragraph which, possibly more than any other paragraph in planning policy history, has been scrutinized by the courts on a number of occasions. The facts of either of the cases don't really matter. Paul Newman is responsible for establishing the first two bullet points that you can see on the slide. The first being that whether there are no relevant policies in the plan for the purposes of triggering the tilted balance, the first trigger, that's all a matter of planning judgment. And then secondly, that the basket of most important policies for the second trigger can be up to date, even if that doesn't constitute a body of policies sufficient to determine the acceptability of the application in principle. And then the third of the bullets is established by Monk Hill. And this was all about the circumstances in which a policy in the framework can be said to provide a clear reason for refusal when applied. And the question was whether such a policy needed to comprise a self-contained test like such and such will be permitted in exceptional circumstances, or whether it went wider than that. And the Court of Appeal said it does go wider, and therefore found that a policy in the NPPF to do with protecting AONBs, which simply requires great weight to be given to conserving and enhancing the AONB, was in itself capable of providing a clear reason for refusal when applied. And as Matt will tell you later, we might not have heard the final word on either of these judgments. But for now, I'll hand over to Matt to take us to the next case.
Thanks, Max. You're clicking through. Thank you. So the next case I'm going to touch on is City and Country Brahms Hill. And again, from relatively early in last year. It arose out of what appears to have been a fiendishly complicated enforcement redevelopment case with, I think, something like 40 to 50, somewhere between 40 and 50 different conjoined appeals against certificates of lawfulness, enforcement notices, etc., all coming before a poor inspector. And the two really important points that went to the High Court and then finally to the Court of Appeal related to two parts of the framework. Firstly, what's now paragraph 80 in relation to isolated homes in the countryside, and secondly in relation to the heritage policies in the framework, and specifically the less than substantial harm test in what's now paragraph 202. I think the really notable thing in some ways about Brahms Hill is that the court, the main judgment coming from Lord Justice Lindblom, very clearly situated itself within the kind of line of authority that we have at the Supreme Court level, from Hopkins Holmes first and then Samuel Smith Tadcaster, which were respectively about what's now a paragraph 11D and then about openness in Greenbelt terms, both of which Supreme Court cases lay down a quite clear language and quite clear guidance about giving a broad approach to policies that aren't susceptible to narrow legal interpretation, effectively. And in relation to isolated homes in the countryside, Brahms Hill confirmed, firstly, the approach of a previous case, Dartford, was correct, that in considering whether or not you have isolated homes in the countryside, you need to look at whether the development would be physically isolated in the sense of being isolated from a settlement, but that within that test or that gloss, both what is a settlement and whether the development is isolated from it are both matters of planning judgment. And just to give you a flavour, in Brahms Hill, the issue is really about whether or not the redevelopment of the mansion itself, the number of units that was going to be provided there, would in fact create a new settlement so that it wouldn't be isolated. And basically the court said, not going into any of that, the inspector understood what was going on, considered what would be a settlement, considered whether it be isolated, and that's for her. On heritage, the sort of key point that arose in Brahms Hill was in relation to what's been called the Palmer approach to weighing heritage benefits, benefits and harm. So Palmer was a case where effectively a planning authority was advised, the committee was advised that there was no need to consider the heritage balance in what's now paragraph 202, because overall the heritage benefits outweighed the harm. So it was net positive in heritage terms. And there's been a lot of argument as to whether that's the correct approach, whether you should net off internally your heritage harms and benefits, or whether you should take them all through and consider them in the context of paragraph 202 with other benefits. That's really important because the heritage policies crop up in footnote 8 as one of the ways out of the tilted balance. And basically what Lindblom, Lord Justice Lindblom said was that something like Palmer is not a straitjacket. It is an indication of one of the different ways which an inspector or a decision maker could take, one of the different approaches they could take towards weighing and totting up heritage benefits. And frankly, there's nothing in either in the statutory duties or in the framework to tell you that one is right and one is wrong. So they're both fine, is the outcome. He also went on to discuss the calibration of heritage harm, which again is something that, inquiry after inquiry, there are arguments about whether we're at the top end of less than substantial harm or the bottom end, or whether it's substantial, whether it's less than substantial. And I think what Lord Justice Lindblom says in in Brahms Hill cast real doubt on whether or not the Bedford case, which suggested that substantial harm would have to be a situation where the heritage significance of an asset has been vitiated or more or less entirely drained away, or very much, if not all, is drained away. And Lord Justice Limblom's approach, I think, cast real doubt on whether or not that reading of the Bedford case could stand, albeit that it doesn't expressly overrule it. So overall, a very strong case for suggesting that inspectors and heritage professionals can take a sort of more robust or a more flexible approach to assessing heritage harm than perhaps might previously been thought.
Thanks very much, Matt. And so the last of the NPPF cases that we're going to talk about today is Asda against Leeds City Council. And this is a case all about national retail policy. And it's a challenge by Asda to the grant of planning permission for a rival out-of-town centre supermarket. And the planning committee recognised that there would be a significant adverse impact on the town centre, but considered that the benefits of the scheme would outweigh the harm caused and granted planning permission. And you might think, well, that's all a matter of planning judgment, and so how could you possibly challenge that? Well, Asda argued that the policy and the framework that deals with retail impact doesn't just say that significant adverse impact is a harm to weigh in the balance, but it instead says that permission should be refused in those cases, thereby giving rise to what the claimants argued was a presumption, albeit one that could be rebutted on the right facts. And they said that the planning committee had failed to recognise that that's what the NPPF required. And the Court of Appeal disagreed with that argument and agreed with the first instance judgment of Mrs. Justice Leven, and held that the policy and the framework that retail development with a significant adverse impact should be refused didn't have a special status in the framework. It didn't set out any kind of imperative to refuse in every case, and instead it required an implicit planning judgment against other factors. And the court basically thought it was irrelevant whether you call that presumption or not. So I don't know if you agree with me, Matt, but I think the consistent theme to take from all of these judgments about the framework is that the Court of Appeal, in particular Sir Keith Limblom, are keen to continue this discouragement of excessive legalism surrounding these paragraphs of national policy, and just asking for them to be applied in a common sense manner by decision makers exercising their planning judgments. I think that's really the main take home point from the framework cases.
Indeed, and I think it's also fair to note that I think Mr. Justice Holgate, as the planning court head of the planning court, he's also making that very clear in a number of judgments, not necessarily from last year, but I've noticed again, just looking back through one of the later cases in the context of plan making, again, I think we can see that Sam Smith and Hopkins Holmes have now sort of percolating their way through. Now, this next case moves out of the world of framework policies into the London Plan, which we now have in a made form, and particularly a challenge in relation to the interpretation of policy D9, which relates to tall buildings. Challenge brought by the London Borough of Hillingdon to the grant of permission by the mayor for a tall building in their borough. And the point that was raised here, which I think is one that not only is important perhaps to note in the context of policy D9, but also given that the way the London Plan is drafted may have implications across a number of other London Plan policies. The point related to really whether or not the mayor or any decision maker dealing with an application is entitled to consider the criteria, the development proposal criteria part of the policy in a context where the kind of plan making parts of the policy haven't been complied with. So here, Part B of policy D9 requires the boroughs to identify suitable areas, suitable locations for tall buildings in their local plans. And Hillingdon had done so, had some policies which pointed to areas, and this proposal came outside of those areas. But what the mayor did was to acknowledge a degree of conflict with that part of policy D9, so with part B, but to go on and assess the tall building against part C, which set out criteria against which individual tall building could be assessed, and to conclude at the end of that that the application was in accordance with the development plan. And the court took quite a close look at the policy, and particularly pointed out that there isn't any express language in the policy as a whole to suggest that either part B or part A, which requires boroughs to define what it will be a tall building in that area, that either of those parts of the policy are gateways to getting to part C. So quite a close kind of textual reading, but I think one which, you know, certainly will have ramifications for consideration of tall building schemes in London, and potentially for consideration of other parts of the London plan.
Thanks, Matt. It's sort of interesting that a policy seemingly so important in the London plan had left open that ambiguity when it was being examined, but I guess that happens all the time.
Yeah.
Okay, so we'll move on now to the next case, and that's Klyn against Walter Lilly. We've included this case because it's a bit outside the usual mainstream run of cases, in that it arises in the context of a contractual construction dispute. So not even in the planning court, but it turns on a question of planning law. And the issue concerned the correct approach to be taken to determining whether construction works are to be treated as amounting to demolition for the purposes of the planning legislation. And this mattered because at the relevant time, conservation area consent, if anyone remembers that, was required for any demolition of an unlisted building in a conservation area. And many of you will know that this requirement for conservation area consent has since 2013 been replaced by the need to instead obtain demolition planning permission. But the principal issue remains the same, which is what does it mean for works to amount to demolition and thereby trigger that requirement? And the concept of demolition was considered by the House of Lords in the 90s in a case called Shimizu, which concerned the question of whether works to a listed building constituted demolition on the one hand or alteration on the other, and that it was a completely two exclusive categories. The House of Lords said it was all a matter of fact and degree. Common sense needed to be applied, but that demolition essentially means pulling something down, i.e. destroying it completely and breaking it up, such that once the work is over, the building's gone for all intents and purposes. However, they were careful to note that the word demolition doesn't simply apply where the whole part of the whole building is torn down, every single element of it. You might have some left standing, but still constitute demolition. And the issue in Klyn was quite a niche point within that, which was all about whether, in coming to a judgment about whether some works constituted demolition, you could assess, if you like, qualitative impacts rather than simply deciding what was actually being done physically. So the Court of Appeal rejected an argument that where a substantial part of the building is to remain intact, consideration of the impact of the proposed retention and the demolition on the character and appearance of the conservation area, could that be relevant? And the Court of Appeal said no. It's a simple quantitative exercise. So you look at the extent of the demolition and you make a judgment, rather than a qualitative exercise which you would reach having regard to impacts on the character and appearance. So that's inevitably going to be an issue which arises in the context of other demolition operations in conservation areas and outside of them.
An interesting case. Up next is there's got to be at least one plan making decision challenge in there, and this one was a decision I I was involved throughout until the final hearing, so I don't get my name on the decision, but I spent a lot of time reading the papers and drafting things on it. It was a challenge to the Cherwell local plan, considered by, came before Mrs. Justice Thornton, and there are effectively two grounds of challenge. One related to the approach that the inspector had taken to the exceptional circumstances case that was being presented to justify Greenbelt release, and particularly whether or not updated evidence through a later schma undermined the housing need case, and whether that needed to be expressly taken into account by the inspector. It's quite a convoluted argument, but it's sort of founded on a series of technical disagreements. But I think what's probably quite interesting in the decision as a marker of how the courts approach these things is it really shows how difficult it is to challenge a decision of a plan examiner, where the grounds that you're seeking to raise relate to an issue that was very much before the examination, because although the claimant here was trying to suggest that the inspector hadn't had regard to this evidence, it was abundantly clear from the circumstances that the inspector was fully aware, and given the standard of reasons that exists in relation to a local plan inspector's report, where the inspector is dealing with a whole host of issues at a much higher level than might be the case on an appeal decision. I mean, I think my view was that ultimately the claimant was kind of doomed by those authorities on reasons, and that's what really kind of narrowed the area. And Mr. Justice Thornton gave quite a sort of sensible and robust judgment, confirming that, in her view, the inspector had been aware of all these issues and taken them into account and reached a view that couldn't now be challenged. Quite a useful just reference to a couple of previous cases. So there was the Calverton decision a few years ago by Miss Justice Jay, which set out quite a exacting approach that needed to be taken to the assessment of housing need when you're justifying an exceptional circumstances case. And Mrs. Justice Thornton was very clear that she kind of viewed that through the prism of a later decision by Mr. Justice Holgate in Keep Bourne Green, which, to link back to what Matt and I were saying earlier, refers directly to Sam Smith and Hopkins Holmes, and sort of rose back from the courts imposing too much of a straitjacket on decision making. Similarly, there was a broad approach confirmed in relation to the policy that in the framework that deals with the replacement of sporting facilities, better and equivalent provision.
Thanks, Matt. Yeah, I mean, I don't know about you, but it feels like it's been quite a relatively quiet year for plan challenges. I feel like there was a flurry of them in 2020. I'm thinking, when you mentioned Keep Bourne Green, the challenge to the Wickham plan, and there's also the Guildford challenge, Sevenoaks, huge number of them. But I guess maybe it's just not been a big year for plans being adopted.
I think there are a number of challenges working their way through, or there's certainly been a few other announced challenges to duty to cooperate decisions or whatever, but I think a number of them have been knocked out of commission, and perhaps some are still chugging their way along.
Okay, so moving away from the world of plan making to something that's probably become quite familiar for a lot of us. This is an important judgment from Mr. Justice Ouseley, clarifying the approach to be taken to considering whether working from home requires planning permission. And obviously a pretty topical issue at the moment, given the greater trend towards working from home during the pandemic. And the context of this is that Section 55 of the Town and Country Planning Act provides that if a material change of use is nevertheless incidental to the use of a dwelling house as such, it doesn't require planning permission. And the court confirmed that the key question to ask when determining whether a use is incidental for those purposes is whether there has been a change in the character of the use, and that environmental factors such as noise and disturbance, like how much is this change actually impacting on neighboring properties, might be they're obviously relevant, those factors, and they might be indicative of a material change of use that is non-incidental, but they aren't themselves determinative of that question. And the judge, interestingly, acknowledged that what is normal or reasonably incidental may have actually shifted in recent times with the changes to work habits as a result of COVID. This was a case that concerned, on its facts, a personal trainer who had used part of his outbuilding as a gym, and the judge found that the inspector had rationally concluded that the level of the use went beyond what was incidental. It wasn't just that he was working out part-time, but had multiple customers coming every week, and it was clearly quite a significant business operation. And what is also interesting is that the judge went even further than just saying that the inspector had reached a rational conclusion. That the judge also said that if the inspector had reached a different conclusion, that itself would have been irrational, which is quite a big thing for the court to say in the context of a rationality challenge. And just shows that the claimant really must have been barking up the wrong tree on this one. Matt, over to you.
Thanks. So next case, Miscellaneous, in the context of permitted development approvals. I mean, I think I'm certainly seeing an increasing number of issues coming across my desk around the new expanded PD rights. And one of the things that's been floating around for a while, and I think Miscellaneous sort of takes us a bit further, but still doesn't fully resolve, is the issue of, what is the role in terms of the local authority in terms of dealing with the question of whether or not the development for which prior approval is being sought, whether that truly falls within the scope of the permitted development right itself. Now, there have been sort of two Court of Appeal cases out there. One is Keenan, which was dealing with a situation where an application for prior approval hadn't been responded to, and the question was well, does that sell the pass on the local authority's ability to say that this isn't PD at all? Answer, no. And then New World Payphones, where it was held that well, it wasn't necessarily clear what was held, but on the approach of Miss Justice Lang, she's taking the view that New World Payphones confirms that a local authority is bound to consider whether or not the development for which prior approval is sought is within the scope of the permitted development right. So an interesting kind of tension, I think, still sits between those two cases and those two approaches, because it seems strange that you can understand why, as a matter of fairness, it might be sensible for a local authority to consider whether or not you are within the PD right, but an obligation on them to do so at that stage sits somewhat strangely with the idea that a failure to raise an issue isn't then determinative or doesn't bind them. And perhaps, I suppose, that might give rise to various arguments about legitimate expectations, etc. But anyway, that's where we are on Miscellaneous, and I think it's going to be an interesting evolving issue going forwards.
Thanks, Matt. Yeah, I've similarly seen a number of instructions coming across my desk about PD rights recently. It does seem to be something which is expanding at the moment. And just to note, for those who are interested in this particular area, there was a judgment handed down towards the end of last week by Mr. Justice Holgate called CAB Housing, CAB Housing Limited, all about prior approval as well. I've not read the judgment; it's quite long. But if anyone's particularly interested in this issue, I know this is strictly outside of the scope of a recap of 2021, but I thought I ought to mention it anyway. Okay, so moving on. This is the first of two pretty niche Supreme Court judgments about planning law in 2021, and it follows quite a big year in 2020 for Supreme Court planning judgments, thinking about the Heathrow third runway decision, Samuel Smith, the case that Matt mentioned earlier about Greenbelt. You also had Dill relating to heritage. So the Supreme Court was quite busy in 2020 on planning, but actually the two cases that we're going to talk about today are both relatively minor, in my view, issues. And I have to be completely honest, I'm not entirely sure how this case got permission, because in order to get to the Supreme Court, you have to show that there's a case of public importance. And admittedly, it is a reasonably interesting point of interpretation, but is it actually justifying the Supreme Court considering it? And I think that was borne out by the fact that when the court heard the arguments in this case, they were so confident at the end of hearing the arguments for the appellant that they took the unusual step of not even calling on the argument on the respondent to make any submissions. And the case is all about the interpretation of Section 61N of the Town and Country Planning Act, which is setting time limits for bringing a legal challenge in relation to neighbourhood development plans. And basically, as many of you will know, there are multiple stages in making a neighbourhood plan, and the legislation provides for specific challenge periods at specific stages of the plan making process. And the appellant tried to argue in this case that a challenger could forego the chance to challenge an interim stage within the specified period, and instead just challenge that interim period at the end of the process when the plan's actually made. And the court held that that's wrong, and that each stage specified in Section 61N is intended to be restrictive in its effect. So if you want to challenge an interim stage, for example, the decision to proceed to a referendum following the receipt of the examiner's report, then you need to do so within the time period specified by the legislation, rather than just wait until the end. So that's that case, and I think we're nearing the end now. We've got one more case from Matt, and then we're also just going to flag a couple of other cases to note, and then Matt's going to talk about things to look out for in the coming months.
Thanks. Yes. So my final case is the Royal Parks Limited case in the Court of Appeal, related to an enforcement lawfulness matter in the West Country, where there'd been a breach of a planning condition, I think in relation to the full-time occupation, non-holiday occupation of various caravans. And the issue basically was whether or not that rendered unenforceable the condition as it related to the whole of the land to which the original planning permission related, or just in relation to those caravans where it had been demonstrated that there'd been a breach of condition for the required period of time. Now, that issue, on the first issue, it's not particularly, I don't think it would get us into our top cases of 2021 on its own. Question of fact, whether it relates to the entirety of the land. So it is open to a planning decision maker to conclude that the condition has been breached in relation to just part of the land. To me, not a surprising conclusion. And then on the second point, and again, this wasn't really, I think this does have a number of ramifications, but it's worth noting that the court, it doesn't form any part of the ratio of the court's decision. The court indicated that it was willing to accept in the principle that a legitimate expectation may preclude enforcement action by a council. So if the council has committed itself to a particular course of action, which wasn't the case on the facts here, or has given a clear indication as to its understanding, and the appellant has relied on it, or the landowner has relied on it in certain ways, that might, in the appropriate circumstances, give rise to a legitimate expectation, which could be relied upon to prevent an enforcement action. I mean, I think there's a number of ways in which that kind of argument could be characterized. It could also be put as some sort of broader procedural unfairness point, or in most cases, it would probably be a breach of enforcement codes, etc., within the authority. But I think potentially a useful case, and one that you may find getting cited around enforcement going forwards.
Thanks, Matt. So they're the 10 cases that we thought were most interesting about 2021, and just a few other cases for you to note. The first is Rights Community Action, which is the Court of Appeal dismissing the appeal in relation to whether the PD rights and UCO amendments that arose following the pandemic, and also trying to encourage more building, more reliance on PD rights and liberalizing the process, whether those amendments set the framework for future development consent such that they'd require strategic environmental assessment prior to being made, and the Court of Appeal agreed with the High Court that they didn't set the framework for future development consent. So something for you to note there. CPRE in Kent against the Secretary of State. This was the second of the 2 Supreme Court judgments from last year. This is all about litigation costs, and it applies beyond planning to all judicial reviews. And it confirms that unsuccessful claimants at the permission stage for judicial review and also Section 288 claims will usually be liable for both the defendant and the interested parties' reasonable costs of filing an acknowledgement of service, subject to any AHU's cap, of course, rather than there was an attempt to basically try and remove that in the course of this appeal, but that was dismissed. And then the last point to note from last year, before we look at what's coming up in the pipeline, is Save Stonehenge, which was the challenge to the DCO, the development consent order for the new dual carriageway and tunnel at Stonehenge. That was quashed by the High Court, by Mr. Justice Holgate, both for failing to consider an alternative proposal that was an obvious material consideration, and also failing to take into account all heritage impacts in the course of doing so. So again, an interesting and important judgment within the DCO context for those who work in that field. So I'll turn now to Matt for the last slide, which is looking at Case on the Horizon, and then we can deal with any questions that follow.
Thanks, Matt. And just, I mean, on the CPRE Kent case, so just to say, I mean, I think it's worth noting with this decision, it confirms what we might describe as the usual situation that interested parties will generally get for their reasonable costs. But I think it's worth noting that it does leave open what those reasonable costs might be.
Yeah.
And that does include, you know, so I've certainly still been involved in a number of arguments about whether it's reasonable for the interested party, say, to have responded on all grounds, and whether there needs to be kind of slicing up of their costs, etc. So, you know, it doesn't. I think in practice we will find that this sort of just parks the issue on a lot of cases, but in situations where a claimant, I think, you know, has the decent grounds for thinking that the IPs come in and lumber them with unnecessary costs, it does leave that door open.
Yeah, exactly. And you do see that a lot, that the interested party basically just duplicates pretty much exactly what the defendant's done. Sometimes they bring more to the party, like they bring a witness statement because they might have been, if it's a Section 288, they might have been involved in the inquiry and
absolutely, yeah,
gave evidence, and so that they might be able to add something about what was going on at the inquiry, what evidence was heard. But yeah, you're right that on a number of occasions I've seen it has been essentially duplication. So the court might be more willing as a result of this judgment to clamp down on that a bit.
Certainly possible. Right, so our cases to watch in 2022. There's the Wyatt case, which actually was 21, but we haven't mentioned, which is a habitats challenge in relation to the approach that's being taken to nitrates mitigation in the Solent. That's quite a detailed technical challenge, basically taking issue with Natural England's advice and the way that's been applied by the council. Quite interesting for those of us dealing with habitats issues, which obviously arise up and down the country, and that will be going to the Court of Appeal, which I think could have significant implications going forwards. And the Hillside Parks case, which is going to the Supreme Court on effectively on the Pilkington point about what's the effect of drop-in applications in terms of whether or not you can build out the original permission. What circumstances does that cause trouble? So that I think will be certainly a case to watch when we have judgment on that. And we're still waiting on Supreme Court for permission to appeal decisions on the Para 11D cases that Matt dealt with at the top, and also on the Asda and Leeds case. And we're waiting for a Court of Appeal decision in a case called Finch, which I think Matt F was involved in, which relates to hydrocarbon exploration and policy approaches and things to that.
Yeah, we should. I would expect there to be a judgment in the Finch case in the next couple of months. And I'm also involved in the NPPF 11D Supreme Court PTA application, and also the ASDA case for the interested party. And both of those PTA applications were made over a year ago now. So it just shows the amount of backlog that there must be in the Supreme Court. They're just so busy with applications for permission to appeal that cases like this, which are quite important points about what does national policy mean, for which have ramifications for a huge number of planning cases. These cases are just basically sitting there waiting to even be determined whether they get permission, and then once they get permission, it's going to be a further several months before the case is actually heard. That's if they do get permission. So that they can't even guarantee that those judgments will be handed down in 2022, but I think there's a reasonable chance that they will be. So that's the end of our slides. We've had a few questions that have come in. Should we just quickly cover them, Matt? We've got a few minutes. There's one about plan making. I don't know if you've seen that.
Yeah.
Do you want to have a go at answering that?
Yeah, no. We've been asked whether or not the potential decline in challenges to plans might be because community or campaign groups don't have enough information, don't have enough knowledge at the time. I mean, I'm not sure about that. I mean, firstly, I'm not sure that overall there has been a decline in the total number of cases. I think just looking at a calendar year, there's always going to be a bit of froth in terms of the numbers going up, a bit of noise in terms of how many cases make it through to a final decision. But I mean, overall, I'm certainly in the examinations I'm attending, I'm encountering a good number of community groups who are, do get well clued up and do have representation either from consultants or lawyers, or even without that, who make very, very effective cases at the examination. So I mean, obviously it's a standard issue that plan making is very document heavy, and that is a significant issue, which I know that the white paper and all the various reforms that have been proposed, or at least kind of whispered about, are partly designed to address. But I'm not sure the situation has got any worse, certainly, than it perhaps was a couple of years ago.
I think I'd agree with that. Yeah. And we've got a question in relation to the Monk Hill case, which is whether paragraph 176 of the NPPF, which is about the great weight being applied to conserving and enhancing the scenic and natural beauty of AONBs, whether that's capable of providing a clear reason for refusal in its own right, even if the proposed development is major development, i.e. when paragraph 177 also applies. And I think the answer to that would be that if it's major development, then that's the paragraph that would be applicable. And if it was determined that exceptional circumstances did exist, i.e. that would be justified to build in exceptional circumstances in the ONB, despite it being major development, applying those criteria, then that would be enough to mean that there was no policy providing a clear reason for refusal. So you couldn't then have the great weight that would independently provide a clear reason for refusal if exceptional circumstances existed to justify the development. But obviously, if exceptional circumstances don't exist and it fails to comply with those criteria, then there would be a clear reason for refusal by applying 177. So I hope that answers the question. Matt, we've also got one here about kind of more a practical question about, is there a useful website which readily lists planning court cases? Are you aware of anything?
Well, there's on the Landmark website, there's a very useful digest which sets out relevant cases against particular policies in the framework. I'm not completely sure whether we've updated it so that we have the current numbers there. It does provide, if you're able to think back to the policy numbers you were using 6 months ago, or no, a bit more than that, a year ago, then it is, I think, a very useful resource in giving you the key quotes from the major cases that have shaped interpretation of those policies.
Yeah, no, I think it's a great idea for there to be such a website that does just readily list all the planning court cases, so that it's easy for practitioners to refer to it. But I don't think you're going to find it. There are obviously a number of practitioner textbooks out there that do their best to keep updated, and as Matt says, there's the NPPF digest. But beyond that, you're just going to be having to do your usual researches, really. There's no magic website which has them all set out. Do we know when Hillside will go to the Supreme Court? I think it has got a date, hasn't it?
I was just Googling it. I was just trying to look on the UK on the Supreme Court website, and I couldn't find it immediately. The answer is I don't know. But
I think it has got a date. I'm vaguely thinking July in my head, only because I've been told the date. But if you want to email me after the session at mfraser@landmarkchambers.co.uk, then I'll get back to you and provide you the date, because I can probably easily find it. Okay, we've then got two more. Let's take two more questions, shall we, Matt? Do you want to go with? There's one about. Do you have any thoughts on HRA for new local plans in the light of the Dutch nitrogen judgment? Do you want to take that, and then I'll deal with the exceptional circumstances point.
I mean, it's not the kind of question. So the question is relates to the Dutch nitrogen cases, which were decisions of the Court of Justice a few years ago that confirmed that where a plan level assessment was carried out, that would only be appropriate to provide the basis for consenting, or to provide the consent for activities within or adjacent to protected sites, if they had sufficient information in them to show that to a reasonable scientific, no, not to a reasonable scientific, to show scientific certainty, to establish scientific certainty that there weren't going to be adverse impacts on the sites. It doesn't, in my view, Dutch nitrogen doesn't change, it doesn't establish any principle that something like nutrient offsetting cannot be used. What it does is confirm the rigorous approach that needs to be taken to establishing whether or not the nitrogen offsetting will be efficient, or the nutrient offsetting will be effective. But I think we also need to read it in the context of cases like Champion, in the UK context, which confirm that judgment is primarily for the planning authority, it's for the decision maker. And I certainly consider that there remains space for local authorities to come up with these sorts of strategic level mitigation programs, where they do so in a rigorous way, taking account of all available scientific evidence, and obviously as part of that, the advice of Natural England is going to be very important, because that's a very good way of establishing that you are following the best available science effectively.
I think that must be right. There has to be a space for planning on nutrient offsetting that isn't just on a case-by-case basis with certain mitigation. There has to be a way to do it in a more global way. following the Dutch nitrogen judgment. Okay, and then I'll just pick I'll cover this quick question about exceptional circumstances, and I've seen we've had one more question. I think maybe we'll then wrap things up after that.
Sure.
Exceptional circumstances, do we think it's difficult to define nowadays? Well, I think it's always been pretty difficult to define exceptional circumstances in all areas of planning and beyond. And the fact that it's not further defined is often deliberate, because the policy intention behind it is to keep things fairly open, recognizing that there are all sorts of eventualities that might arise which will justify being exceptional in a particular case. So yes, it is difficult to define, but deliberately so, I think, in order to cater for that width of what might come up and justify it in any given case. And obviously you will get guidance on exceptional circumstances. There's been, for example, guidance from the courts about what exceptional circumstances might be in the Greenbelt context, very special circumstances and all of that. And then you also, I don't know whether this question's particularly got in mind the AONB analysis, but as you know, in paragraph 177 of the framework, we know what the NPPF has in mind when it's thinking about exceptional circumstances because of those three listed criteria. Yeah. So that's certainly a good indication of what they're after, but might not necessarily tell you the whole story. The rest is really up to your facts and whether you can make them sufficiently exceptional to get the consent that you're after. Matt, have you got any thoughts on this last one? And then we'll wrap things up.
I mean, it's obviously, so the question is, the questioner posits that we are reaching a difficult point where Greenbelt authorities won't accommodate their housing needs, receive no cooperation from adjoining authorities, and that will result in housing need effectively being unmet, and draws attention to I think it's Christopher Chope's private members bill, which is I don't understand exactly its terms, but which proposes to add a further level of legal complexity to the process of removing land from the Greenbelt. I mean, I think it is right to say that there is in housing, it's perhaps the fundamental conflict of our development management system, between the desire to provide sufficient homes, particularly around major urban centres, and the desire to encourage regeneration and prevent urban sprawl, and cynically protect nice green boroughs which vote for a particular party. In terms of where I think this is going, I mean, I think the current mood music seems to be that we're swinging back towards the protection of the Greenbelt, in my analysis. Although levelling up may result in greater powers finally making their ways to different parts of the country who may take different views to say how the London boroughs are doing. I mean, I know that there's been obviously a lot of argument around Greenbelt retention in the context of London, both in terms of the London plan and its adjoining authorities, but it's not an issue that is going to be solved in one stroke in any direction. It's really a question of degree as to what extent Greenbelt is released. And I suppose from one perspective you could say, well, all of this pressure is what hopefully is delivering good schemes somewhere, and perhaps we are seeing a large number of regeneration and housing schemes in London. I'm doing an inquiry on one in a couple of weeks, which involves new higher residential buildings being constructed in London, and that could be viewed as part of the success of the Greenbelt. But it's certainly an issue which has a number of facets, and where I don't think we're going to stop talking about Greenbelt release anytime soon.
Thanks very much, Matt. And I think that really we'll draw stumps at that point. Thank you very much indeed to everyone for attending the webinar today. I hope you found it to be interesting and informative. As I said at the outset, if anyone has any questions they didn't feel they were able to ask, for us to answer, then please get in touch with either or both of us. We'd be more than happy to discuss things further with you. Please stay tuned. There's going to be all sorts of other landmark webinars coming up in the future. But for now, have a good rest of the week. Thanks.
Cheers. Thanks very much.